Welcome to the RestoreYourRights.com questions and answers video series by Lorkie Law. I'm attorney Jesse Lorkie. I'm going to talk about letters of support in rights restoration cases in Oregon. This video is going to be useful if you're trying to restore your rights and want to get letters of support to provide to the judge, district attorney, or county sheriff, depending on whatever the case might be. And it's also going to be useful if you've been asked to write a letter of support by a family member, coworker, or friend. Okay, let's get started. Today we're going to talk about what makes a good reference letter of recommendation in a rights restoration case. I think in general, the first rule about support letters is quality over quantity, and that goes for both the number of letters and how long each of them is. And I'll talk about that in a minute. But here, you're looking for 1 to 3 letters from people who know you pretty well. And you don't have to shy away from family, parents, spouses, siblings. Those are people who know you the best and are able to give a different perspective than somebody who is an acquaintance or your employer. You're going to want people who know what convictions you had that led to whatever you're doing now, so that they can address that and address whether that's the kind of behavior they see anymore, or if that is a stage that they're glad you're out of, which is the kind of perspective that a parent can give. So again, in general, 1 to 3 people. Every situation and case is different, but that's a general advice. The letters don't have to be very long. A half page to a page works pretty well because there's really just a few things to address, and you want to make sure that people are actually reading them. Back to that quality over quantity. Everybody involved has a lot of stuff to read, and you want them to actually spend the time getting through, and you can say what you need to in a half page to a page. As far as what to put in the letter, if you're the person writing it, you should say how well you know the person you're writing it for. How often do you see each other or talk to each other? Have you known them a long time but don't see them very often now, or whatever it is. Essentially, you're trying to establish that your opinion means something, that you know this person well enough to have something to say about whether they should be granted whatever they're getting. Which brings me to, they do need to let you know what they're asking for and what is holding them back. If it's a driver's license restoration, is it a person who would be safe to drive, that you know that they're not going to drink and drive or use drugs and drive? Or if it is a firearm rights restoration, that they're somebody who's responsible and safe. You'd expect to be safe with a firearm, not the type of person the judge should have to worry about. And that's kind of what it all comes down to, is we have to convince a judge that this person isn't going to end up getting them on the front page of the newspaper because they went out and did something stupid with whatever the rights were. So the input of people who know this person and see them day to day is valuable. Whether the letter can be evidence or not depends on the situation, but they're valuable in and of themselves in setting the stage for what a hearing would be like if it had to happen. A letter should be in your own words, and it should be truthful, of course. As far as the format, it can be addressed dear judge or to whom it may concern. The formalities are not going to get in the way here. It should be neatly written if it's going to be handwritten so that it's easy to read, or typed out. It can be emailed, preferably to the attorney, so that it doesn't pass through the person who's going to be in front of the judge along the way. It should also have some contact information, so it's clear that you're legitimate and not just a made-up source. No one's likely to get in touch with you, but it does make the letter make it more authentic. It's nice if a letter can be signed and then, say, scanned or mailed in as a hard copy. That really works great, of course, but whatever gets it in, part of it is don't be intimidated by the legal process. So that's about it. They don't have to be real long, half page to a page, explaining how well you know the person you're writing about and why anybody should listen to what you have to say, and whether they're a danger to themselves or others, or whether they're rehabilitated, whatever it might be, whether they should get what they're asking for. Don't get uptight about the format and getting it in. Mostly just get it in to help the person, and his attorney and him can decide whether the letter is useful or not. I hope this video was useful. If you have any questions about letters of support or rights restoration cases in general in Oregon, then get in touch. You can visit us on the web at RestoreYourRights.com. It's easy to set up a free consultation with one of our attorneys. Again, I'm attorney Jesse Lorkie with Lorkie Law. Thank you for watching. Goodbye.